This session, Stephanie, as you know, is a partner of Brian Cave, has worked on a number of particularly bond default cases for indenture trustees, Clean Energy Futures and a raft of others. And there's a rumor that she wrote a book on indenture trustees and their bankruptcy powers and duties. So Stephanie, let me turn it over to you.
Thank you, Harold. I have a wonderful panel that I'm going to introduce, but first of all, I want to tell you a little bit about our topic that we're going to speak on this morning. Litigation with issuers, which was once relatively rare, is now becoming increasingly commonplace in defaulted bond situations. And very oftentimes that occurs either in the run-up before bankruptcy or during a bankruptcy. This litigation and the surrounding bankruptcy almost invariably requires, demands a lot of communication and coordination between the indenture trustees and the bondholders. The reason for this is that there are standard provisions in indentures that require essentially the exercise of all remedies to be channeled through the trustee. Our panel will talk about current hot topics that arise in these cases, and in particular the interface between the trustees and the bondholders, and specifically decisional points that are faced by the indenture trustees and the bondholders in these cases. There are 3 or 4 topics that we're going to cover. The first one deals with the pre-bankruptcy period and the role of the indenture trustee vis-a-vis the bondholders in the pre-bankruptcy situation, and specifically the role and function in connection with ad hoc groups. And we're also going to discuss the whole concept of prearranged plans and what that means for bondholders and for trustees. Second topic, we're going to talk about the role and the roles post-bankruptcy and how that changes specifically in the context of Chapter 11 committees. Third topic we're going to touch on is the challenges that arise in connection with the exercise of remedies by holders and trustees and ways to make that process go more smoothly. Fourth, if we get to this, we'll talk about the whole conflict and resignation situation, how and when a trustee may have to resign, how successors are chosen, and what concerns and questions bondholders often raise in that context. And then lastly, we're going to talk about everybody's favorite topic, which is compensation. And specifically, given the challenges to trustees' fees and expenses, what challenges that has presented with respect to collection of fees and whether it impedes the whole resignation and successorship process specifically. So I want to introduce my fabulous speakers. I'm really excited about this panel. I obviously speak a lot on this topic, and it's rare that I have had such a energized and relevant panel to this conference as the one I have today. To my immediate right is Steve Kraus. Steve is with Owl Creek Asset Management LLP, where he's been since August of 1913. Sorry about that. This is really a blast from the past. 2013. He focuses on process-driven situations and special situation opportunities. Before joining Owl Creek, he was with Davis Polk, and also before that with William Case. He had been a practicing bankruptcy lawyer before joining the bondholder role. He has substantial experience both as a lawyer and at Owl Creek in a range of corporate matters, specifically with focus to restructuring and bankruptcies. He's currently co-chair of the ABI's Business Reorganization Committee, as well as a number of other organizations and appointments. And I do, at the risk of embarrassing Steve, will tell you that he has a very impressive classical education, graduated from Harvard, undergraduate, UCLA Business School with Management, and also a law degree from Columbia, where he was a Harlan Stone Scholar. I feel that he brings a unique perspective to the bond side because of his very fine classical education and also his very impressive training as a lawyer prior to joining L3. To the right of Sam Starr, to the right of Steve is Sam Starr, who is a senior managing director at FTI Consulting in the corporate finance restructuring practice based in New York. Sam is well known to probably everyone in this audience. He specializes in providing services to creditors in Chapter 11 cases and out-of-court restructurings. He has more than 25 years of experience in restructuring and has diverse industry experience and is a leading advisor to creditor constituencies. He's also noted as an expert witness, particularly in the area of valuation. To the right of Sam is my former colleague, Mark Heblin, who is presently a partner with the Chicago office of Foley & Lardner. Mark is a bankruptcy partner at Foley, and his practice is concentrated in the area of corporate restructuring and particularly the representation of trustees and bondholders. He also represents creditor committees in Chapter 11 cases. He has been involved in a number of national, highly visible cases, including most recently Energy Future, Exide, and Caesars. He's written extensively on bankruptcy issues, and he has been recognized by turnarounds and workouts as one of the top restructuring lawyers in the country. And with that, let me turn to our first topic. Oh, and let me give you a little commentary about what's on the screen. I would like to take credit for this, and I would take credit for the graphic, but I have to give credit where credit is due to the concept, which came from David Dunn at Aeropress, who some of you probably know. And what Dave has talked about is the concentric circles of distressed debt. And notice that we have the bondholders in the large circle, because they're actually in every circle. They interface with, in the first yellow circle, the advisors and lawyers, which are the FAs, the investment bankers, and also the indenture trustees that are really part of the advisors to the bondholders. And then the small circle is management, which is really the debtor, the issuer, and their lawyers, their advisors. And during a bankruptcy case, I felt like this really, to me, graphically illustrated how the relationships between these three groups of people, and particularly the indenture trustees finding themselves in the middle circle with interface both with their bondholders and also with the debtor and the issuer in a situation. So the first question that I have for the panel is the subject of prearranged plans. Are prearranged plans a thing of the past in light of the recent failure to effectuate these plans after a bankruptcy is filed? For instance, the Energy Future situation. And does this recent experience in specifically Energy Future and Caesars, is this going to lead to an increase or decrease in the formation of ad hoc groups across the capital structure? Sam, what's your perspective on that question?
One thing that I'm curious about is whether, in as much as RSAs never end up being the final deal, that does seem to be the case in the current environment, whether having an RSA provides a benefit of shortening the time in Chapter 11, or not. And I know it's hard to this is a very subjective question, but what's your perspective on whether it shortens the time in Chapter 11? Or don't get the RSA approved. Enter into the RSA and then put it on a fairly sluggish time frame to tee it up for approval, because that's when things go wrong. You bring it to the judge doesn't approve it, and then you do blow everything up. On the other hand, we've seen cases where issuers, debtors, have run cases as if the RSA was in place, operating by the milestones, even though it's not been approved. And it does, I don't know, I'm interested in your perspective on this, whether the timing in and of itself that's driven by those milestones has a effect on the case, in the sense of allowing the parties that have signed the RSA to drive the outcome, even though the RSA it never gets approved as such, and the parameters of the deal change during the bankruptcy. They still control, like on the twilight zone, or maybe with the outer limits, like I control the channel, I control, that's sort of what I feel RSAs do now. As to whether the duty kicks in or the authority kicks in under the statute after a default, not necessarily, in other words, before a capital D event of default. But in terms of the actual ability to exercise a remedy, that only occurs after an event of default. So, trustee can legitimately get involved in a situation once there's a default.